All right, in this video, we are going to go ahead and break down the approved judgment by Justice Mellor in the Craig Wright, COPA v. Wright case, and also, some specific points that haven't really been looked at, and new evidence from a whole different case that could completely send this whole thing back if the Madden report gets in. So this is Gavin, Mehl. Check this out. Stay to the end. We'll break this down on a Zoom here so we can kind of show the screen, but so stay tuned. All right, so this was approved by the court on the 20th of May, as you can see right here. Mellor, Crypto Patent Alliance, Craig Stephen Wright. Now, I want to go through page 96. Well, starting on page 95, actually, it's a common features of Dr. Wright's explanations of the forged documents. So various technobabble, et cetera. But let's go through very specific grounds. Again, this all is based upon Madden, right? So any of these, what they're calling forgeries, first of all, are better described as the metadata. I mean, it's highly technical metadata, dude. It's not like a guy signing a forged document over again. It's metadata on a computer, right? So this is what they're calling most of this stuff. A forgery is metadata on computers and these things. So that's pretty much where Madden is basing, just to kind of give a basis on it. It's rather kind of ridiculous. But all right, so anyways, let me just go through here. Madden says deliberate forgeries by others. Wright claims that it was Ira Kleiman or Edgar Hansen. Now, if you remember, most of the documents, what Wright had done in this case is he did a huge data dump of all the files from Kleiman. There were like all over the internet, there were like 1 million pages of documents. Here you go in a big old file. Have a good day. And he gave it to the other side. And then a lot of this stuff comes from that. Imagine how many thousands of people touched that stuff afterwards. All right. So just as a little premise here, that literally is one of the things that happened. Now, so that's why he's saying Kleiman. Now, Edgar Hansen. All right. Edgar Hansen. What's going on is he's also saying Edgar Hansen. Now, the court's saying that this is totally frivolous, accidental alteration by others, not working literally. Now, down to page, page right here, 406, this is page 99. In view of the general unreliability of Dr. Wright as a witness, plus the fact that he had no independent expert evidence, this is a big problem. Dr. Wright didn't have proper independent evidence to rebut the allegations. To support his assertions about the effects of the relevant computer environments, I agree that they carry little weight. Further, to the extent of any of his assertions had some validity, I'm satisfied Mr. Madden took account for them. So again, everything comes down to Madden. So even if Wright had, if without Madden, the court is basically saying, well, we'd have to give what Dr. Wright's saying some credibility. But I'm satisfied that Mr. Madden took account of any of those. So that's the kind of the basis there. Without Madden, there isn't much of a case, right? There isn't much of a case for COPA at all. So that's why I'm going back to that stuff from the last video that we talked about on Madden and how it was let in by error according to the rule, the standards, the legal principles. But here's something that's new that needs to be looked at. 409. Nevertheless, counsel Wright relied on some additional points. First of all, the alleged hack by Mr. Ager-Hanssen prior to dismissal from nChain, which I discussed below. So he goes into what was alleged about the nChain hack with Mr. Ager-Hanssen a little bit. He says, Dr. Wright stated in his belief that Mr. Ager-Hanssen had access to his company laptops from around May 2023 forward. All right, so Mr. Ager-Hanssen, he introduced this around 63 to 67 above. Although Wright's assertion about certain answers in the cross-examinations that were a conspiracy against him involving COPA and Mr. Ager-Hanssen. COPA said in their closing statement they had nothing to do with Mr. Ager-Hanssen. Big deal. That's not testimony. Okay. Just because COPA said that, that's not testimony. All right. So I'm going to show you what is testimony. What is evidence? For all this relies on this judgment. Dr. Wright's various deletion of forged documents that were planted. So the court's basically going through all these statements that these documents, if there were any, they were planted. And Ager-Hanssen or a bad actor had access to this stuff. So a bad actor had inserted content which was whatever this word is, in 2007-8, edit the content. Fifth, the hypothesis assuming that a bad actor must have been extremely fortunate. Not only did Dr. Wright proceed to nominate the documents they had tainted in his critical reliance documents, but he also failed to notice that any of them had been edited. Instead, he studied the documents and produced the instructions to shoesmiths and detailed 97 documents. That point being, at this point, Dr. Wright was actively collaborating with Mr. Ager-Hanssen. So he's saying around the point of September 5th. Now he's saying, the court's saying that he was collaborating with Ager-Hanssen. But here in 417, Dr. Wright asserted that these documents were planted by Mr. Ager-Hanssen or someone else. Overall, now here's the conclusion about the bad actor. Overall, the notion of a bad actor was responsible for forgeries on the BDO drive is literally incredible. It would depend on multiple bizarre coincidences that the combination of which was completely implausible. Now, look at this. Date, 3/5. Hearing dates, May 3rd. Approved judgment, May 3rd. Prior to the judgment, they're coming out. So in the same court, Royal Courts of Justice, in the commercial court with a different judge in the High Court, King's Bench Division. Here's another case, nChain versus Ager-Hanssen. Now, this is not just a case. This is a judgment, meaning that it is absolutely judicially noticeable to the court on appeal. In fact, I think it's mandatory judicial notice in this case. Well, I'm not sure what the rules are there, but it should be mandatory judicial notice because it is a 100% related case. And this judgment here on May 3rd was approved prior to the court's decision. So now let's take a look at what it says. Again, be mindful of this last statement here, what Mellor says. Overall, the notion that a bad actor was responsible for the forgeries is incredible, literally incredible. It would depend on multiple bizarre coincidences, the combination of which was completely implausible. All right, it's totally implausible that a bad actor could be involved, huh? Okay, so this is an approved judgment by nChain against Ager-Hanssen. And it states here, the second relevant order. Now, it's going through some of the contempt stuff, which just basically says that Ager-Hanssen is going to be sentenced to jail or prison for 10 months. Okay, so what? What matters is really what it was ordered by the court. Second, in my review, the significant order when I come to deal with the sanction is non-compliance with paragraph 2 of the Mr. So non-compliance with these orders by Ager-Hanssen. Ager-Hanssen was ordered by January 26th to deliver up the following devices to the claimant solicitors. nChain being a related, party of Dr. Wright, obviously Mr. Matthews being he was the the chairman of the board of nChain, and Dr. Wright at one point was a part of nChain. So that's why it's relevant. Levano desktop with this serial number, MacBook Air with this serial number, iPhone 14 Pro with this serial number. This was an order for delivering these claimants of the property in evidence back to the parties. This was never satisfied. So therefore, paragraph 4, it read as follows. Surrender the following devices to the expert. MacBook Pro, confidential information, surrender hard copies and documents that Ager-Hanssen had back to the expert. And then Ager-Hanssen failed to do this. This was back in January. So in a related matter, Ager-Hanssen was ordered to show his innocence, to show his non-involvement, what's he got to hide? Just produce this stuff and provide it back to the expert. Ager-Hanssen failed to do this. He failed to comply with the court order. So therefore they sentenced him to 10 months in jail. Upon this, which would have been just a couple of days ago, the sentencing took place. So therefore, this is an approved judgment. So again, Mellor is somehow not taking notice of this, because if you notice here, it's implausible. Implausible? How can it be implausible if you have a judgment here? This is not a claim is one thing, a complaint. No, this is a judgment. This is already approved by the court that there was a bad actor, that this bad actor has stated, has has failed to comply to show his innocence. And all he had to do was comply and produce this stuff to the expert. He failed to do so. So again, this is something that needs to be judicially noticed to the appellate court to support. I mean, it's how much more obvious does it get? Dr. Wright saying that they were planted by Edgar Hansen. Well, before while Wright was making those points, this judgment hadn't become final yet. It wasn't until May 3rd. Now, Dr. Wright's claims were supported that there was a bad actor. And it was Edgar Hansen. He's been sentenced to jail for 10 months. And specifically for his failure to produce these documents and produce his innocence. Okay. All he had to do was show that these documents, give them to the expert, let the expert review them. And he wouldn't do that. Okay. So by default, his failure to comply, okay, the court found him guilty. That is final. It's not an allegation. So if that's not some sort of interference through espionage, then I don't know what is. All right. So yeah, get this video over to I'd say the Dr. Wright side, because they're writing the appeal right now. I think it's I don't know what day. Anyway, somebody's going to be doing a notice of appeal. They should be reviewing this and taking notice of it. I mean, it's obvious, but you never know, because I mean, I work with a lot of attorneys, and sometimes they get so lost in the weeds on the legalese that they miss the main points. And you got two main points here. Number one, Madden. All right. The standards, the legal standards for for an expert's independence. Those legal standards are laid out in that prior video that I put out, but let me just go through them really quick. Yeah, the legal standards: experts' evidence should be independent product of the expert, uninfluenced by pressures of litigation. Chemical Industries versus Mehl Technology. You got experts have the duty to provide objective, unbiased opinion to assist the court. Same case. Supra. Lawyers preparing the first draft of the outline of an expert report can risk influencing the expert views, so they should generally be avoided. The first draft, right, is saying that, well, let's just say that it was like the court saying in Phillips on evidence, the lawyer should avoid writing the first draft. The first draft. What about the whole thing? All 6 reports. Experts' reports must comply with paragraph 22.1 of practice guides, which states, quote, this is the practice guide on experts. Expert evidence should be the independent product of the expert, uninfluenced by the pressures of litigation. There's the standards, dude. What seems to be the problem with that? Paragraph 22, 35, also emphasize the expert should provide objective opinions to assist the court, not assume roles of advocates. All right. So if the court's even stating that there are 8 meetings and then Madden admitted he didn't write the report, all right, and they wrote it. It wasn't just the first draft. No, they wrote the report. That was the testimony. So how are the standards? You know, the appeal is what are these new standards? Where's Mellor getting these new standards from? Because he's saying, well, he saw in a lot of patent cases before that the experts wrote the reports, or that the attorneys wrote the reports. So what standards are these for a patent case, that Meller's using? Is there a standard for patent litigation? And why would a patent litigation case affect a identity under a declaratory and equitable relief action? Strictly equitable relief. That's all this is, declaratory relief. How is that relevant to a patent case? So that's the first main point. That's the main point. And then the second point here is the interference, which we just went through today. Edgar Hansen now has been found guilty of, I mean, it looks like, I don't know if the case was about corporate espionage, but I don't have the complaint, but it's espionage with nChain. And he's been found guilty of espionage and failure to and his charge is failure to surrender all these this evidence, the MacBook Pro, the desktop, iPhone, and that's a final judgment that's been held down and sentencing has gone through. So those two things right there are the main point. Try not to get lost in the weeds in this appeal. And if so, this bad boy goes back. There's too much. I get it. Wright did a bad job. Shame on Wright for not doing better. people, I mean, I would say shame on Wright for not doing a better job at getting his case, at proving his case. One thing that Satoshi had shown me was Wright. You know, he had been on Facebook in 2009 when the Bitcoin system was released on block 1, and he was posting about it on Facebook. Now, maybe that wasn't genuine, but I don't know. Maybe it was. But why? I mean, I see the article. You know, it was on a blog or something. So, anyways, it's on a Facebook post. Why didn't Wright use that? That would have. That's one thing. There's other things. I mean, I think that Wright should have brought more of a case. But again, that's all crying over spilled milk. You know, for people who for Wright, you know, whatever, he didn't. Nothing that can be done about that. What's done is done. But what can be done is this appeal can overturn the whole thing for a poor error in law on the standards, okay, of admitting the expert report, and then also this interference by a bad actor, which is now not an allegation. This is a judicially noticeable fact and law with the Ager-Hanssen case in the same courtroom. Share the video, get it out to Wright's attorneys. All right, leave a comment. Wednesday, doing a Twitter space about a town hall. Wednesday, it's going to be at 9 a.m. Pacific, 12 noon Eastern, 5 p.m. UK time. So tune into that. Should be fun. We had one on Sunday, and we'll do a little town hall space just to recap on things and have some influential people talk about what the heck's going on. Just town hall, not just about this case. You know, I mean, this case is just it's a turning point. Like, where do we go from here? You know, and I just happen to love this stuff, and so that's why I talked about it. For me, it's entertaining. It's fun. I enjoyed it. I love kind of reporting on it. And hey, I might as well, if I can add value to one of the sides here to overturn this case, well, good. Get it to them. Let's get it done. I'll see everyone at the top.